How difficult is it to meet a Social Security disability listing? I'm Jonathan Ginsberg. I'm a Social Security disability attorney, and I represent clients in all 50 states. And I'm able to do that because Social Security hearings are now done virtually by telephone or by video. So location doesn't matter. The judge can be in one state, I may be in another state, you may be in a third state, but I handle cases really for clients in all 50 states. And if I can be of help to you, please visit me online at ssdanswers.com, and you can learn more about what I do and how you might be able to get a hold of me there. I want to talk to you today about Social Security listings. How difficult is it to meet a Social Security listing? Now, you may have seen my website called meetalisting.com, and if you've watched my videos, you know that meeting a listing is one of the 3 arguments you can use to win a disability case. And the listings, just to recap, are where Social Security has identified certain medical issues that on their face are disabling, meaning that rather than have to focus a lot on the vocational issues, the diagnosis alone, along with associated medical records, in many cases is enough. So, for example, if somebody has terminal cancer, having that diagnosis and some supporting medical records is usually enough to convince Social Security that you are in fact disabled. Having a heart problem where you're on a transplant list, that is a level of severity that Social Security will assume that you are disabled. And there are 14 body systems in the listings, and again, go to meetalisting.com if you want to see them, where they've identified medical issues within each of these different body systems. You've got musculoskeletal, you've got cardiac, you've got mental health, you've got cancer, you've got immune system. There's again 14 of them. And so within each one, there's multiple diseases, let's call it, that are described by the listings, that if you meet one of these listings, you're found disabled pretty much automatically. And the nice thing about the listings is if you can meet a listing and prove it, you can win early, which means you can file an application, get an approval within 3 or 4 months, and move on down the road. However, there's a catch, and that is that Social Security makes it really, really, really difficult to meet the listings, and especially in those type of medical issues that are the most common ones they see. So, for example, back pain is the most common medical problem that Social Security sees. Therefore, listing 1, which covers musculoskeletal problems, is the hardest listing to meet. A lot of people complain of depression and alleged disability based on depression. It's a mental health condition, anxiety, depression. That's another one. They make it really, really difficult to meet. So, you know, I have people call me sometimes, they email me or call me and say, you know what, I look at this and I meet this listing. Why are they denying me? And the reason for that is usually one of 2 things, and both having to do with evidence. One is that Social Security has not been able to obtain the evidence they need to decide that in fact you meet a listing. When you apply for disability, you provide Social Security with the names and addresses of all the doctors and hospitals you've seen. The Social Security adjudicator then sends out a letter along with your 827, which is the medical release you sign, and they ask your doctors or the hospital to return medical records. Well, sometimes the doctors do and sometimes they don't. A lot of doctors, you have to realize that in the medical legal world, medical records are a cost for many medical practices, and when let's say a personal injury attorney writes an orthopedist to get medical records, the medical provider will usually have a fee schedule. They may want $150 or $200 for those medical records, where Social Security, being a part of the government, says we're only going to pay $15 or $20. So the medical provider may send a letter back to the adjudicator, you know, our charge is $150. The adjudicator is like, we're only going to pay $15 or $20. You've got to produce this. The medical providers or the copy service usually says, forget it, we're not going to do it. Therefore, the medical records don't get produced. Now, if you knew that, maybe you could go in the portal and get the records, or maybe you go to the doctor and get them directly. But you'd be surprised how many times people get denied who have serious medical problems simply because the medical provider did not provide or the copy service, again, is probably the more accurate way to put it, did not generate the medical records and return them to the adjudicator. So that is one major problem. And again, you can cut this off or head this off by asking your doctor to cooperate with Social Security or downloading the records yourself and sending them to the adjudicator yourself. That is one way to deal with that. The second and probably bigger problem is that many of the medical records that doctors provide don't meet the evidentiary requirements that Social Security has set forth forth in the listing. Now, I was just looking at listing 1, which is the musculoskeletal listing, and there is a whole section there, and I think it's about 7 or 8 paragraphs that describe what evidence they need. So, for example, one of the things they talk about is needing radiological evidence, like an MRI or CT, but it's got to be a recent MRI or CT. A 3-year-old MRI isn't going to help you. A 6-month-old will. A 6-month-old MRI is going to help you. It's got to be done within normal standards. So in other words, if the MRI talks about this is not a good study because there was movement, that may dissuade Social Security from considering that MRI. Associated medical records need to discuss vocational or activity limitations. Some doctors in their records, they talk about the medical problem itself and the treatment, but they don't talk about the associated vocational limitations unless you ask them. And I guess one of the things that lawyers like me do is we ask the right questions and ask the doctor to fill out forms that discuss vocational issues. But a lot of times the medical records themselves don't talk about those things, or they're buried so deep in it that the adjudicator is not going to find it. I mean, I look at medical records all day long, and it's not uncommon for a medical record for someone who's seen a doctor for 3 or 4 years. It could be 300, 400 pages. And buried on page 177 is some notion or some reference to functional limitations. Well, if I find that, I can make the judge aware of it or the adjudicator aware of it, but the adjudicator, him or herself, is a claims adjuster. They're not going to go through, and no knock on them. They're busy. They're not going to try to dig out all of this information from these medical records. So a lot of times it's just about making sure that the adjudicator or a judge sees the actual relevant medical record, because if it's not there, if it's not apparent to them very clearly, they're just going to say, well, I don't see it, I'm going to deny. I was looking at another part that was talking about assistive devices like canes. Well, was that cane prescribed by a doctor? Was it a recent prescription? If it was not recent, was it reevaluated within the last 6 or 8 months? You may have a cane that was prescribed 3 or 4 years ago, and every time you go in to see the doctor, I'm still using the cane. That's great, but it doesn't make it to the medical record. As far as Social Security is concerned, that's an out-of-date prescription for a cane. So you see, their standards for evidence have to be comprehensive. It's got to be comprehensive medical records that talk about vocational issues, and it's got to be recent things. It can't be something that's 5 or 10 years old. They also want to see what they call longitudinal treatment record. You saw a doctor once or twice 6 or 8 months ago, that's probably not going to be enough. But if it's somebody you've seen for a year and a half, 2 years, 3 years, that's going to make more of a difference. If you change doctors, and the new doctor who you started seeing 4 or 5 months ago doesn't reference that he or she read the old records and that is kind of incorporating those into his or her treatment, that may not help you. So a lot of times it's just a matter of the adjudicator doesn't see what I call magic words in the medical records that allow him or her to decide, yes, you meet a listing. A judge might see that, or if you have an attorney who points it out to the judge, you may have that there. So if you get denied, if you think you have a listing level claim, A, realize really hard to meet a listing, and it may be that you just don't have quite enough to meet the listing. B, the medical providers have not produced the records for Social Security. That's a very common thing. And 3 is that the magic words that really track the language of the listing are not very clear on the face of the medical records. They're voluminous, they're hundreds of pages, and nobody at Social Security at this level, at the administrative level, is going to take the time to parse through that and find all that stuff. So that's why you may think you're listing level, but you may not be approved based on the listing. And again, you get turned down. You have to go through the reconsideration appeal then to a hearing, and that's again where attorneys get involved, and we're able to make a difference by making sure that the evidence that is really relevant to the issue at hand, that is your work capacity, is front and center and very apparent as to what that is. Or we ask the doctors to produce evidence, to create evidence in the form of a functional capacity evaluation that would address those functional issues. Please visit me online at ssdanswers.com. I've got a free Secrets to Winning Disability Survival Kit there, as well as a place you can ask for a case evaluation. Also a lot of FAQs and other good information about the disability process. If you thought this video was helpful, I would really appreciate it if you'd give it a thumbs up and a like on Facebook or on YouTube. Leave me a comment. Let me know what you think. Let me know if you've had different experiences or want other videos. The more interaction, the better in that regard. And if I can be of assistance to you, again, reach out to me through ssdanswers.com. For now, this is Jonathan Ginsberg, wishing you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.